Crime Chat. Crime Chat with Jared Decent. Good evening and welcome to another episode of Crime Chat. I'm your host, Jared Decent. Tonight we'll be giving you a very special episode on evidence law. We're going to be talking to Professor Courtney Attender, who is an expert in the area, and getting his opinions on a few recent cases and finding out how evidence law really operates in the courtroom. Specifically, he'll be talking to us about the intricacies of witness credibility and the difficulties that arise when a witness must testify long after the events of the case have occurred. Professor, it's good to meet you and thank you for coming on the show.
My pleasure, Jared, and thank you for having me on.
Do you mind if I call you Court?
No, not at all.
All right, well, let's get straight into it with the first segment of the show tonight, guys. It's called Testifying After Time. The number to call with your questions is 1-800-555-555-343-1000 Crime Chat. Now, it looks like we've got a caller on the line already. Mr. Ralph Bogan. You have some thoughts on the issue of witness memory, Ralph?
Yeah, g'day, Jared. Evening, Professor. How's going? I just think it's so stupid that you can compel someone who might not remember exactly what happened to give evidence in a situation where, like, documents and the seriousness of giving evidence in court, you know, where they are required to produce an answer, might implant fake memories in their mind and overwhelm them and might cause them to attest to a fact or situation that they don't even really actually recall, you know?
Yes, thank you, Mr. Bogan, and that's an excellent point. It's been referred to and spoken about by Chief Justice Spiegelman. Yeah, he's the former New South Wales Chief Justice, and he speaks about the term plasticity of memory, and he's talking about the process that you mentioned, by which a document, you know, produced for the purpose of reminding a witness of what happened, actually forms a new memory of events in the mind of the witness that may or may not even be accurate according to their original thoughts on the matter. So, you know, this new memory can supplant the old fading memory because they are new and because people like to make connections in their mind so that things make sense. Of course, there are legal provisions to prevent this from happening to an extent. Section 32 of the Uniform Evidence Act provides that before a witness can refresh their memory, the court must give leave, so that requires consideration of matters that are listed in Section 192, subsection 2, and two additional discretionary considerations for the granting of leave must also be considered, and they are: 1, whether the witness exhausted his or her memory, and 2, whether the document to be used for refreshing memory is one that the witness actually wrote of the events in question when they were fresh in his or her memory, or were found at the time to be accurate.
Could you give us an example of this provision in action, Professor?
Yes, so this is clearly resonant to a case I saw recently, actually, R and Isakaitis, and I attended that case last week where the Crown witness repeatedly stated that he did not recall the events that the prosecutor was referring to because they happened, you know, some 4 years ago. He was constantly being handed these loan agreements to refresh his memory and valuation reports and other documents. There were two things that might strike a layperson or a student about the process. Firstly, I'd say there was no reference to the provision or any of the factors to be taken into consideration under the provisions. He was just handed the documents when they were needed, implying that there is not a positive obligation on the judge to allow such documents to be utilized. Rather, in practice, there is an assumption that a document will be allowed for the purposes of refreshing the witness's memory, and an obligation on the judge or the imposing party to intervene if they feel that the documents should not be omitted for such a purpose. And secondly, the witness really giving the prosecution no help, which is surprising, given the fact that they obviously called him for this reason, and brings us on to the next part of the show, I believe.
Yes, that's right, Professor, and thank you for that. The next segment is credibility.
Yes, credibility, precisely, and a great topic and one worth talking to. I mean, I could talk about it all night, Jared. The prosecution was also exhibiting some quite strange behaviour in trying to accredit the witness. Although he realised after several attempts that the witness was not a lawyer, it seemed he was trying to somewhat invoke the witness's, you know, legal education to imply to the jury that he was trustworthy and intelligent. But this, in fact, is actually prohibited under Section 102 of the UEA because it constitutes accreditation of one's own witness. The writer Julius Stone wrote in his book Evidence, Its History and Policies that if the party has reason to believe that a witness is not to be believed on his oath, he has no business to try and support his case by his testimony. He may not, therefore, if the witness's testimony is unexpectedly unfavourable, be permitted to mend his case by proving that the witness whom he deliberately brought forward is mendacious. So in other words, he cannot just discredit his witness just because the witness didn't say what he wanted them to say.
Okay, Professor, we have another caller on the line. Thank you for that. This is Ben DeCourt. Hey, Ben, what's your take on all this?
Hey, well, no, it's not really a take on it. It's more like, I just don't get how a witness can just not help the party that called him like this Harper bloke was doing. I mean, sorry, surely they couldn't have expected him to just sit there and not remember anything or pretend he doesn't. Isn't there anything they can do to get him to cooperate?
Professor?
Yes, thanks, Ben. And yes, you're quite right, in fact. I'm sure the Crown thought Harper would be more useful to their case, and they were actually visibly frustrated by the lack of information they obtained from him by the lunch break, you could tell. But there are provisions suited to this exact kind of situation. It's generally not allowed to cross-examine a party's own witness, but in situations where the party can establish that they aren't making, and I quote, a genuine attempt to give evidence on a matter reasonably supposed to be known to them, under subsection 1b of section 38, again, a court may grant leave to cross-examine under that section. If that happens, then the cross-examiner can ask leading questions, pursuant to section 42, and attack a witness's credibility, pursuant to section 103. So applying that to the case in question, yes, I think that Harper could definitely have fallen into section 1b of subsection 1b of section 38, in that he was being asked to comment on his own work as an employee of a corporation, and was answering in short, unhelpful terms. I mean, even when the prosecution had moved past his inability to remember specific instances to questions regarding the standard procedure that he would have had to comply with in such a position. So these were not subjective questions asking for his opinions, and nor were they delving into the realm of memory of specific facts. They were simply objective questions about procedures in matters reasonably supposed to be known by him. In short, it seemed he was kind of flirting with the line of giving a genuine attempt to give correct evidence. So, in that kind of instance, where when you take away the issues that we've discussed about the plasticity of memory and all that, and the witness is still being supremely unhelpful with issues the prosecution knows that the witness knows about, then these provisions, yes, they're very, very helpful, and they give you permission to totally change the stage and start attacking the witness's credibility in order to show the jury that this guy's evidence, who's possibly being purposefully undermining your case, is not actually worth putting any weight on. The provisions are needed in these instances. I mean, the witness actually approached me outside of the courtroom and wanted to discuss the case with me, and he told me, in these exact words, he wasn't going to let these lead him places he didn't want to go. I mean, of course the court doesn't have the explicit statement from him, but it's pretty obvious that he was channeling that attitude through the way that he was answering questions. He was quite unhelpful, and anyway, I hope that answers your question, Ben.
Ben? No, it looks like we've lost Ben. We haven't got long left, unfortunately, so you know what that means, everybody. It's time for Hot Topic Time. And as this is a special evidence episode, we'll be taking any questions on evidence law proceedings, so give us a call on 1-800-555-555-555 343 1000 Crime Chat. Okay. Oh, look, that was quick. We've got Lenore on the line. Lenore, are you there?
Yeah, hi Jared. I just wanted to say I'm a really big fan. I listen in every week. Anyway, I was watching CSI last night and they kept mentioning this leading question business, like where they disallow the question or something for some reason or another. I was just wondering, what's that all about? You know, it's like, because is the lawyer trying to trick the witness or what? It's a bit confusing.
Professor?
Yes, thank you, Lenore, and that's an excellent question, and it relates well, actually, back to the case that we've already been discussing, this Isakitis case, and particularly the questioning of this witness, Mr. Harper. Leading questions are defined in the dictionary section of the Act. They're basically any question that can directly or indirectly suggest a particular answer to the question, or a question which assumes the existence of a fact which is in dispute in the proceedings. In the Isakitis case, one of the facts in dispute between the parties was whether the witness had seen a valuation report. When the Crown asked the witness, "What did you think of the report?" the defence counsel objected, and the question was disallowed by the judge, for being leading, since it presupposed that the witness had seen the report.
Oh, okay, but why aren't they allowed though?
Well, because they presuppose an answer or the existence of a fact, they might therefore lead a witness to attest to something that they might not have meant to, you see. So, especially if they didn't realise that the question presumed the existence of a fact. So, and then you might have a jury who would use that information in their decision, which might be unfair for the accused. So, you can see that the reason for this is about protecting the right of the accused to a fair trial. That's kind of the human consequence of all this.
A bit clearer for you now, Lenore?
Oh, I get it. Yeah, thanks, Professor. And thanks, Jared. I love you so much.
Oh, well, thank you, Lenore. Very, very kind of you. All right, folks, that just about wraps up everything for this evening. Unfortunately, we don't have any more time. But thank you very much, Professor Court Attender, for your insights into the field of evidence law. And I'm sure it's been a real eye or ear opener for our listeners. Stay tuned for the next episode where we cover the ins and outs of the most interesting offence of all, murder. That's it for us at Crime Chat, where we bring crime to the people. Good night.